I don't know. After hearing him calm and talking about the tether story, it's probable.
Let's go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
Probation. What's going on? This is Colin. How's everybody doing? Happy Thursday. Hope everyone's doing well. I see the names rolling through the chat. Welcome, welcome. Good to see you all. Hope you had a great day today. All right, we got some courts kind of going everywhere like yesterday, just jumping from court to court. Let's see. What do we have tonight? We got a little bit of Judge Bryant, Judge Washington, Judge Simpson, of course, and we have a Judge Middleton. Like I said, we're bouncing around everywhere. Anyways, before I hit that play button, you already know what to do. Hit that like and subscribe and do your jump kick backflips. Let's go.
This is case number 086029701. The people of the state of Michigan versus Marcel Ramon Oliver. Defendant is charged with retail fraud. It's on the court's docket for a review. Who is that at the table doing? What is going on at my table? Okay, okay, bless the assurance. Okay, appearance, please. Can counsel stop doing that at the table on the screen? Can we acknowledge that we're in court? Can we do that? Okay, appearance, please.
Rakidia Hall on behalf of Marcel Oliver.
Table, can counsel move from the table? It's very distracting. It's very distracting. Can counsel move from the table? Okay, your appearance, Ms. Hall.
She just kicked an attorney out. So he's not even working on this case. This case is all over Zoom. He was just sitting there at the table, probably getting ready for his case to be called. Yeah. Yeah, Judge Bryant didn't like that, though.
Rakidia Hall on behalf of Marcel Oliver. Sir, may you unmute yourself and state your full name for the record?
Unmute. Unmute, Mr. Oliver. Well, Mr. Oliver, you certainly can unmute because you had to unmute in the breakout room. Someone had to unmute you. Someone had to unmute you. Okay, so then all you had to do is tell them to unmute you, Mr. Oliver.
They're in another room. I gotta go out of here. They're in another room. Let me go.
You don't have to go out, Mr. Oliver, because clearly you can tell that I can hear you because I'm talking to you.
Okay, well, yeah, they're not in this room with me. They're not in this room. They're in another
conversation. We're literally having a conversation. Mr. Oliver, please state your name.
Marcel Ramon Oliver.
Thank you so much. Today is the date. This is what I'm not going to do. I'm not going to do this.
You can't hear me. They said it's not mute. You hear me? They unmuted. Can you unmute it?
All right, let's go to another case. And then we'll come back to that one. Okay. Okay. All right. Let's go to another case. Okay, I'm gonna bring them back out. Let's go ahead and bring.
Yeah, I was just gonna say I don't think they go to another case. I got a little worried.
What I want to know is why the jail called them, because they know they heard us. Why did the jail call them? They know they heard us talking. That's why they unmuted them. Okay. Good Monday morning, Ms. Hall.
Good Monday morning.
All right, let's go. Oh, okay. I know. It doesn't matter. Mr. Oliver, here's something we're gonna do. Mr. Oliver, you're not gonna just randomly talk. That's what's gonna happen. You're not gonna just randomly talk. We are literally in court. We are in a court proceeding. My court reporter is recording. And you're not going to just literally start talking, nor are you going to get up and answer telephones while the judge is talking. I mean, I don't care who's calling inside of that room. I literally don't care. they're gonna not call inside the room because the person who called inside the room, they knew we were on court because that's why they unmuted you when I asked you to unmute. Like literally. So what we're gonna do is make sure that we are abiding by court decorum at the jail. Now, I don't know which jail facility you're in, but I'm gonna need you to abide by court decorum, and I'm gonna need the people monitoring to abide by court decorum. All right, so Ms. Hall, I think in the middle of all that, you had placed your appearance on the record. We had gotten Mr. Oliver's name, and then today is the date set for review. And they tell them to leave us alone, Mr. Flanagan. Just tell them that I said leave us alone. We don't need that. We don't need it. Just tell them to leave us alone for right now. Okay, today is the day set for review. Let me check my email. I did ask Mr. Flanagan to send me a copy of the Register of Action. Because this is a very old case, and Mr. Oliver is clearly in custody of the Michigan Department of Correction, and he was originally sentenced back in 2008 by my colleague whose name I cannot read. So I don't know. Oh, I guess I could go up here and see who the judge was. Nope, it doesn't tell me. So one of my colleagues sentenced him. He was supposed to do 30 days of community service. That's all he was sentenced to do. That was back in 2009. Ms. Hall, are you aware of how long he's been in custody of the Michigan Department of Corrections?
Yes, Your Honor. He was actually previously in the custody of Michigan Department of Corrections from 2009 to 2018.
And then now he's back in their custody?
Yes, he said that he's only been there for a few days. I don't know the amount of days for the current time, and he'll probably be doing at least another year.
All right, then the court is going to amend Mr. Oliver's sentence to give him, this is ridiculous. Mr. Flanagan, you didn't tell, you didn't give him you didn't tell him, can the young lady move out of the thing? Okay, no worries, Mr. Flanagan. All right, I'm gonna amend the sentence to 30 days in the Wayne County Jail. I'll give him credit for 30 days served. We will close the case out with improvement. Bid Mr. Oliver adieu and good luck. And do you all see how we didn't need them to interrupt the proceedings to give him that remote?
We now call 21-384.
You know, we can't have a video by me if other judges don't interrupt the judges talking.
Need them to interrupt the proceedings to give him that remote? Do you literally see how we did not need them to interrupt the proceedings to give him that remote? I promise you, if people let Judge Bryant do her job, I promise you court would run much smoother. Ms. Hall, anything else for the record?
Nothing else for Mr. Oliver, Your Honor. Thank you.
And Mr. Oliver, you have a great day, and good luck to you. Stay safe, and this case is closed out. We will send the paperwork over to the jail, put to the prison. All right. I'm ready.
That's exactly right. I mean, I cannot be the head jabroni if I don't do stuff like that. Otherwise, I'm just a regular jabroni. Got to be the head jabroni. All right, now we're headed to Middleton, where I probably have another judge interrupting that case too. These are older cases, and the older ones I have, I don't generally go through them as thoroughly as the newer ones. I apologize. Not really, though. Got some Judge Stevens. You didn't know Judge Stevens was going to be here?
And we'll address that matter. Are you Jack Detweiler? All right, he's on the next case. This matter is file 231433GC. Mr. Bryant Groen is here on behalf of Citibank. This is entitled as a motion to set aside a default.
We are attempting to bring it back. We had a talk about that. It was like a week or two ago. So we're trying to bring it back.
This lawsuit was filed sometime last fall, September. Mr. Lafferty was served with the lawsuit personally by a process server on Saturday, October 14th, although he declined to sign for it. He was personally served. No answer was given, and the plaintiff moved for a default judgment on December 13th. It was actually signed, and that default was in the amount of a lot of money, $22,787.41. The defendant, within 21 days, wrote a letter dated January 2nd. The 13th, in fact, I think it was the 21st day, essentially asking me to quote unquote revisit this case, and then gave some explanation as to why he was asking to set aside the default. There is a certain standard, Mr. Lafferty, that goes with a motion to set aside the default. We'll discuss that here in a moment. Mr. Groen, what's your position regarding the defendant's request to set the default aside?
Well, as I'm sure the court is going to address, there's a two-prong review system in such circumstances. First prong is good cause, whether good cause is shown why an answer wasn't filed. In reading over Mr. Lafferty's written response, I really didn't see any good cause listed in terms of why, after being personally served on October the 14th, why he did not file an answer. Since the judgment was not issued until mid-December, he got over twice the normal time period in order to file an answer, and he still did not do so. Second prong for such a review is whether there is a meritorious defense to the underlying claim. There is no meritorious defense listed in his written response. Also, his written response does not necessarily align with what's indicated in the credit card statements that Citibank forwarded to us. So I'm looking at the June 2022 statement that had a zero balance. And then Mr. Lafferty racked up about $1,500 in charges at the end of May, early June of 2022. The next statement, additional $3,000 charges. So all these charges emanated from 2022 and forward. The last payment Mr. Lafferty made on this account was in September of 2022. The reason that the account was charged off is because he stopped making payments. The account was charged off in May of 22, or May 22nd, 2023, and then we filed this lawsuit shortly thereafter. So based on the totality of the circumstances, there's no good cause shown, no meritorious defense. We ask that the motion be denied and the judgment stand.
Your Honor, if I may.
Yes, certainly.
Okay, so that is not 100% correct. Long story short, my wife passed away. It'll be 2 years this 13th of February. Yes, we used that credit card since I think it was 2013. that my wife opened the card, and my wife was the primary. I was the secondary. Did not realize that. She passed away while we were in Nevada. We used that Citibank card that we had had for years when we would make these big trips because of the balance, or the available credit. Long story short, my wife passed away on the 13th of February while we were in Nevada on 22. Yes, I used the card. I used the card to secure my wife's body, to bring her back to Michigan, to pay all of the fees and stuff from hospice and the funeral home there. I did pay the card large amounts. I made a $10,000 payment. I made a $12,000 payment. I was paying the card off. I wasn't neglecting the card at all. Okay. When I got home, I buried my wife. I continued to use the card. I'm not going to deny that. Okay. The problem is that I have is through all of the struggles and things I've learned, because my wife, she was the numbers girl. I was the guy that went out into the field and worked. I did not know who was primary, who was secondary. I didn't even know that mattered until my wife died. And I proceeded to call credit cards to pay her debts and found out that they wouldn't take my money because there was some rule or law that said I wasn't the primary on the card. Whether I was a user or not, they could not accept my money. So long story short, months after she passed, I was at Costco, and I'm sure that this gentleman will see the last transaction on that card, which was at a Costco. I went to Costco. I had gotten some kind of a reward deal. I called Citibank on this reward. I don't lie. The gentleman was asking me questions. I informed him my wife had passed. He immediately shut the card off right there. And all I did was call on our promotion. And that's the truth, no matter what. So the gentleman shut the card off, and his explanation to me was because my wife was the primary and I was a authorized user. So with that being said, I was very frustrated and I'm flat out pissed because I had been paying that card off to go through the process of dealing with my wife's loss, paying bills, keeping lights on, get my son to college, blah, 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 blah. I called back a couple of weeks later just to verify, because of what I had learned, what do I need to do to pay this off? And I was told that they would not take any money from me because I was not the primary. I let it go. As far as what this gentleman said, as far as I did not sign anything, I was not offered anything to sign when I was served. The gentleman showed up in a Ford Ranger in my driveway, handed me paperwork, got in his truck and left, never offered to sign anything or asked me to sign anything. I was in contact with his law firm for weeks on end, was told that this was being looked into, because I explained to them that I was not the primary. I'd attempted to pay the debt. I'd attempted to do what I needed to do to make it right, and no one had ever gotten back to me. So then I received the letter that the judgment had passed, and I was flat out pissed. And I called the law firm back, and I talked to a lady, and just last week, I'd explained to her the whole situation like I just said to you. And I said, I don't understand, because of what I've been told by several other companies and what I have researched, why I'm getting hit with this. So I said, could you please send me something?
You're getting hit with it because you made $22,000 worth of charges on the card after June of 2022. The balance was at zero in June of 2022, several months after your wife died. Now, maybe
Correct.
you charged all those things as funeral expenses of that sort of thing, but you're being hit with it because you charged $22,000 worth of stuff. Mr. Groen, you want to speak to that?
The charges that came through.
Stop. I'll give you a chance to speak. Go ahead.
I can't. Number one, the statement that I indicated showing the zero balance it is Mr. Lafferty's name on the account, not his deceased wife's. This is his account. I see charges as late as November of 2022 for Watson's in Kalamazoo for a $6,500 charge. There was a Central Tile Terrizzo charge, well over $3,000 made in July of 2022. These are all charges made by Mr. Lafferty well after the fact. The statements show his address, his name on the account. And
Your
he's
Honor, I'm not denying it.
I'm still speaking, and he has not denied that he's the one making these charges.
And that's just it. But what I am denying is the fact that your company, when I called to make an attempt to pay the debt, shut me down. I am not the primary on that card. Citibank has told me that. The reason they shut that card off, no, don't tell me no, because I have this in on the phone call. I called to make a request because of a thing that I got through Costco. And those dates you're talking about, yeah, those are prior to the card being shut off. Okay. And I was using the card because I assumed it was mine. I did not know.
It was yours.
No, it was ours. It was mine and my wife's. Okay.
Well,
So
those weren't unauthorized charges. There's no fraud involved.
no, not, and I'm not denying that I used the card for that. Okay. I'm not at all, Your Honor. That is not what I'm saying. Okay. What I'm saying is when the card was shut off, and I'm sure that gentleman can tell you.
One of the problems, we're not under oath. I called somebody and talked to somebody whose name I don't know on an uncertain date, and they told me something, which is all hearsay. But Mr. Groen, do you have any notes in your file that the defendant discussed the matter with anyone from this firm?
I see a call after the judgment was entered. I see notes on December the 19th that he called and offered to pay this, but also informed the collector that his wife passed away and that he was only a authorized user and that this was not his account. So
No,
at that
sir.
point in time,
No, that is incorrect. 110%. What I was told is the card was shut off. I didn't ask him to shut the card off. So just hear me out. It's my turn. Okay. I called. They your client shut the card off. I didn't ask him to shut it off. And it wasn't shut off because of lack of payment. It wasn't shut off because I was behind. It was shut off because my wife was the primary and she had passed. That was what they told me.
that's not accurate.
So why was the card shut off then?
All right, well, just stop. You haven't met the standard to set aside the default. There's no good cause shown as to why you didn't answer the matter in a timely manner. You've acknowledged that you were personally served. More
I was in talks with them
before the judgment entered. And there is no meritorious defense. You made these charges well after your wife died as an authorized user of the card, and they're owed.
Right, and I'm not denying that.
You can pay it. So the
But that's
motion
where
to set
I'm
aside
upset
the
because
default-
I tried to work with them, Your Honor. That's what I'm saying. In between the time I was served and the judgment was sent to me, I had been in talks with a law firm, and these people were telling me they were looking into this because my wife was the primary. They don't know why I was getting served paperwork. They don't know why I'm getting the bill. And then in between the time I was served and the time I got the judgment, I had been playing phone tag with this law firm to get answers because I called the court.
All right. I see, so, when this case started, people were kind of on his side a little bit. And then as it went along, people are jumping sides. But so I believe him that the bank shut the card off. I absolutely believe that. A bank will do that. If you tell them the person passed away or they get notice of someone passing away, they will shut that card off in a second. And if there's still money in the account, like if it's a bank account, you will have to go up with a death certificate to retrieve the money. We had to do that with my mom. We went through a similar situation with my sister. My sister was using my mom's credit card for something that was auto paid every month, and nobody told the bank that my mom passed, but somehow the bank found out. I don't know I don't know how any of that works. But it was shut off and a bill didn't get paid. And that's how we found out that it happened. Now, I don't believe them that the bank wouldn't take the money that you owe. I don't believe that part at all. So that's the part of the story that doesn't make sense. I do believe the car was shut off, though. I do believe that.
They said, we suggest if you can, you call them and see if you can settle it before it goes to
Well, you
court.
can discuss settling it now, but you owe this money. These charges were made. You made them.
I
There's
never
no
denied that.
Stop. There's no meritorious defense. Now, you got sued. You didn't answer the lawsuit. About 42 days passed and a default judgment entered. On the very last day, you wrote a letter asking the court to reconsider it, which I considered as a motion to set aside the default. And there's a standard for that. Now, I don't expect you to know this. You're a layperson and you don't practice law, but I'm bound by it. It has to show there was good cause for failing to file an answer, which I don't find. And two, that there's a meritorious defense. There is no meritorious defense. You acknowledge that you made the charges. So I'm going to do an order denying your motion to set aside the default, and the judgment stands. Now, you can contact the law firm at this point and see if you can negotiate some sort of payment schedule or get something to compromise this debt. But this is your debt.
You're correct. And while we're on here right now, and this is on record,
Yes,
because
sir.
I've done this on the phone with this gentleman here, I have told these people, even before we got to this point, what do I need to do? I'll set up a payment plan. I'll do whatever. I was going against the judgment because I didn't want it on my credit. It's not that I didn't want to pay it. I don't want it on my credit because they instantly went right to my credit, and I got a $22,000 judgment against me. I have made, and I'm sure
I either wasn't clear. If I misconstrued the story a little bit, I'm sorry. If I wasn't clear when I said it. No, my mother passed. My mom passed. My mom was paying something like a bill for my sister, but it was just on a reoccurring payment, and my sister would just give her money for it. I don't know. I don't know what they arranged. But that it didn't get paid because the bank closed down my mom's card, and nobody had even gone to the bank and told the bank that my mom passed. So the bank did it on their own. They somehow found out on their own that she had passed. So that's what I'm saying. Like they'll just shut it down when they get notice of the person that has the account once they pass. That's what I meant. I hope that cleared it up a little.
sure if Brian wants to go back and get all the recordings, I have made the calls, asked the questions. I have not denied not making the charges. I have gone through the process and was told what to wait on and what to do by his client or by his law firm, excuse me. Hence the reason, it went to the last minute. I just received a packet from them last week that I requested over a month ago. So I understand dragging feet and taking time and busy, but I have done my part. I don't deny making the charges, and I haven't, and I won't. That's not the point. The point is I was trying to get resolution as to what I needed to do to avoid getting it on my credit. All that's according to their law firm and the number you call, it's all recorded. So it's not like I just let it go. That's what's upsetting me. I have made if you look at the
Let me ask you this. How many times did you talk to their law firm by telephone?
before the judgment, several,
How many is several?
at least 5 or 6 times. I talked to 3 or 4 different people, and they were looking into the fact that they couldn't, the people that I was talking to, that is in reference to the phone number, the debt collection portion, they couldn't understand why I was getting all of this stuff from the law firm and all of this stuff from Citibank when my wife was the primary. And I told them, I said, look, I was using the card. I was paying on the card up until it was shut off. And then they wouldn't take my money.
All right.
That's the point.
Well, they'll take it now. Mr. Groen, can you see when the last payment was ever made on this card?
It was September of 2022. He was making that large payment, that $6,000 purchase, was a couple months after the last payment. And that explains why the card was charged off, is because he had stopped making payments, and it was well
That
over
is
the
not correct.
credit limit.
That is 100%.
We sent you the statements, and they'll have them on
The card was paid every month. I got a bill. The card was shut off. You can get upset all you want.
All right, well, there's no need to get upset. I ruled against you. The motion to set aside the default is denied. You owe the debt. You can call the law firm and see if you can set up some sort of payment plan or otherwise resolve this, but it is on your credit. And again, nobody was under oath, but your version and his version don't match
At all.
And many of these charges were made months after your wife passed away. And
Yeah,
they
I thought it
were
was
fraudulent. You were authorized to use the card and they shut it off because payment had been stopped. So you'll get a
Oh.
copy of that order. You do have the right to appeal it.
okay, and that's fine. It was
All
not
right,
shut
thank
off.
you. All right, Mr. Groen, I got other fish to fry here. We got behind right off the bat.
it. Good luck to you, Your Honor. I appreciate it.
I will do the order denying the motion to set aside the default.
Attaboy J Mid, he just hung up on him. That guy was gonna talk forever. Every time something different came out, he had a story about it. Yeah, he didn't pay his bill. It got shut off because he didn't pay his bill. They just said it right at the end. It's like, you made a $6,000 payment or a $6,000 purchase, and your last payment was a couple months before that. Yeah. It got shut off for lack of payment, man. Not because you called, you had what do you say? He got an offer from Costco. Anyways, all right. Let's move to Judge Simpson's court. I think all these clips are from today. Yeah, I think they're all from today. I think I grabbed 3 of his clips from today. So let's go. Wait, no, we're not going to Judge Simpson yet. He's after this. All right. This is a magistrate. I never remember his name, but Simpson's after this.
2359797. 230-59797. People State of Michigan versus Shakia Bonet Boykin. Appearance for the people.
Judge, good morning. Always a pleasure to see you. Steve Vincent for the people, P71917.
Good morning, sir. My pleasure.
Jessica Shive on behalf of Ms. Boykin, who is from a reading, understands her constitutional rights and stands mute.
Did my ears just pop, or is this video really loud? It's coming through really loud on my headphones, but yeah, my ears may have just popped because I don't know.
Good morning. Court waive formal reading and her plea of not guilty. Ms. Boykin, the court scheduling 2 court dates. You must attend both of them. Probable cause conference scheduled Tuesday via Zoom, February the 20th at 8:30, 36th District Court, Judge Sabri. You have a right to a preliminary examination in person, February 26th. That's Monday, in person, 8:30, 36th District Court, Judge Sabri. Understood those 2 court date and times you must attend, Ms. Boykin?
Yes, sir. In person, right?
The February 20th is via Zoom, February 26th in person, 8:30.
Did I leave myself on mute when I came in to talk? Are you guys making fun of how loud the video is? I just I put the volume to 50%. Yeah, it was really loud. And when you guys were saying it was loud, yeah. So I lowered the volume on my end. Hopefully that lowers it on yours too.
Judge Sabri, 36th District Court, understood?
What's the time I'm still be in jail February 20th?
If you are, the jail should accommodate. If you're released, it's via Zoom, but otherwise they'll be notified of your court dates.
Okay.
Not guilty plea is entered on your behalf as the bond from the people.
Respectfully, Judge, there's a lot going on with this defendant. And, and I want to put this all on the table just to give Your Honor some perspective. She actually was just arraigned on a case, an aggravated stalking case. It was actually one of my cases that ended up going into, I believe it was arraignments over the weekend. She ended up getting a $30,000 cash bond because allegedly an individual who had a PPO against her, she ended up going to that individual's workplace, started to assault him, and then pushed him into oncoming traffic, where an actual semi truck ended up having to swerve out of the way to not hit that individual. And Judge, by the way, that individual was almost 80 years old. So she was arrested on that. She ended up, she was given a $30,000 cash, but Chief Judge McConico, in his wisdom, and I do respect it, ended up just converting that to a personal bond. But now we have this matter, which I'll get into, as well as the fact that there's a case under review for another PPO violation, as well as an aggravated stalking. Now, in this particular situation, Judge, which predates the one that was just in redeterminations, these allegations are this individual stabbed somebody, and it was caught on green light surveillance. And Judge, apparently the surveillance ended up catching this defendant as the aggressor in that situation. She stabbed somebody not just a few times, but enough times where that individual ended up sustaining stab wounds to their legs, as well as allegedly their face.
Are you talking about the other matter that's, well, one moment, Ms. Boykin. Are you talking about the pending matter, the other matter that's pending?
Oh, I'm sorry, Your Honor. The matter that I'm speaking to right now, those allegations are for the case in front of you today. Unless I have this case as being an incident of stabbing an individual at a gas station.
It happened a year ago.
Ma'am. Okay. One moment, ma'am.
Now, Judge, there are multiple.
The allegations I have on this matter took place, just for clarification, on allegedly the Otsego location, where it's alleged that Miss Boykin lit a chair on fire and poured lighter fluid on the fire, causing it to grow. And then also alleging throwing pillowcases and milk crates onto the fire, causing a damage to the residency.
Yeah, and let me just give, again, let me give this court some perspective. There were so many open cases having to do with this individual. The case that I'm speaking to is another case. And then we have an aggravated stalking case that's in review, and then that ongoing case. So this one must be an arson case that you're speaking.
Well, they charged, yes, arson, misdemeanor arson, and a 4-year FA. And these allegations took place in 2021.
And Judge, I was speaking regarding an FA that happened in July, that this individual, I guess she's going to be appearing before this court on this one, as well as then the additional aggravated stalking that's under review. I guess, Judge, the long and short of it is you have the allegations regarding the case that's in front of us today. I have allegations about a case that's going to be brought forward in the very near future. And then there's one in the pipeline. Quite honestly, Judge, the defendant's a danger. She's violated PPOs. She's stabbing people randomly at gas stations. Now we have arson charges.
I'm not stabbing people randomly at gas stations. He assaulted me. He put a knife out on me first.
Ms. Boykin?
I'm going to ask you again, Ms. Boykin. Don't speak out over the top of people. That's disruptive and it's rude. The prosecutor is making his argument. You have defense counsel here.
Danger to the world.
Well, he's making his argument, Ms. Boykin, and he's doing a good job. Let him finish. Go ahead. I apologize, APA.
No, and Judge, I can understand because she has a lot going on and she's dealing with a lot and she's violated a lot and it's probably high stress and high tension. But with all of that being said, Judge, I was speaking to an FA case. You have an FA case in front of you. She has an ongoing case regarding an aggravated stalking. There's another aggravated stalking in the pipeline, Judge. Respectfully, I'm going to be asking for $30,000 cash. It's what she was given initially in the case over the weekend that was converted. But I think at a certain point, the cash is going to stay, Judge, just based on the totality of the circumstances that this defendant is posing a danger to a number of people now. We have your incident that has to do with a different individual that I was speaking with that has to do with another individual that she ended up breaching a PPO order for. So respectfully, Judge, I'm going to be asking for 30,000 cash. I understand it's just an FA, misdemeanor arson, but I think looking at this thing in the totality, I think, it's reasonable to say that she's a danger on many different fronts.
Thank you, counsel. Response.
Your Honor, Ms. Boykin suffers from severe mental illness. She's been asking for help. Every time we're in front of the court, we say we need the proper resources for her. I know that this court can't, we would hope that they had the resources to help her in that way. Ms. Boykin needs help. She suffers from severe mental illness. People unfortunately mess with her because a lot of humans do not treat people with mental illness very nicely. She is attacked. She tries to defend herself. She can't even explain to the police what's happening, and she always ends up in jail. We're really hoping that she gets the proper help and care that she needs, because clearly Ms. Boykin, yes, has a lot of things going on, Your Honor, but she is suffering from mental illness severely. And unfortunately, even the police sometimes are not trained to deal with these situations. The incident in front of you right now that she is being arraigned on is from 2021, Your Honor, and it was not entered until 2023, November. We are now in 2024. The complaining witness is the father of her child, and that is the individual that she was going to get tethered to, because when she got that $30,000 personal bond with the tether, that is where she was going. That's where she was going to get tethered to. That is what she was waiting for, that tether to be tethered there. Now, if the court is not comfortable with that, given this case, we've already had the conversation with Ms. Boykin that she's going to have to provide another address to be tethered to, and she can and will do that. I know it sounds strange, but give it, Ms. Boykin, 1 second. But I know that, this is from 2021, so they've resolved their differences, but she understands the no contact. That's what the court's going to say. So she's already has a tether. This is a 2021 matter. This is what's in front of you now. I'm respectfully asking the court to consider a high personal bond. If the court's going to say no contact with this complaining witness, then she understands that, and she already has a tether, Your Honor.
Thank you. Ms. Boykin, these are very serious assaultive allegations, and I do have concerns regarding the safety of this complaining witness and the safety of the public at whole, given not only your prior criminal convictions, which the court's aware of, a malicious destruction of property, a felony conviction in 2005, assault with a dangerous weapon, felony conviction 2014. Roughly 17 days prior to that, we have another felony assaultive conviction, assault with a dangerous weapon, felonious assault. And now we have pending allegations that the court's heard advocacy from APA, as well as the information alleged in the investigator's report, which there is a likelihood of conviction according to the allegations alleged. I've taken into consideration any employment status, as well as your mental health presented by your counsel and employment as it relates to ability to post bond. Here it's alleged that you were seen, witnessed by a neighbor going to your ex-boyfriend's home, banging on the door, and were not let in. It's alleged that the neighbor seen you start to set the house on fire with chair, pillows, milk crates, all set on the fire on your porch. And it's further alleged that upon making contact with the complaining witness, when he opened the door, or when an individual complaining witness opened the door, you were equipped with a bottle and a bat in your hands, and you allegedly struck him across the face with the bottle, causing injury. And then fled the location. And so the court has a number of concerns, Ms. Boykin, regarding the safety of the public, your intention to appear and handle this order or this matter as ordered. We have flight allegations in the investigator's report. We have serious assaultive allegations. You have assaultive convictions. You have a number of pending matters, which is concerning. And given specifically the matter before the court regarding these allegations, and the court does find in order to set a unaffordable bond, Ms. Boykin, the court must find by clear and convincing evidence that you are a danger to the particular complaining witness, an individual, or the public at whole, or a flight risk. Given that your number of assaultive convictions, the information presented by both parties, as well as these investigators report the nature of these charges, the court does find by clear and convincing evidence that you are a danger to Mr. Farmer and the public at whole. For those reasons, the court is going to set an intentional unaffordable cash bond, finding a personal bond will not adequately protect the safety of the public. Bond for that reason is going to be set in the amount.
And Judge, I don't mean to interrupt this because I know you're going to give your bond amount, but I would like to put one thing on the record to counter what defense counsel said. None of.
All right. I love me some Vincent. Prosecutor Vincent is one of my favorite prosecutors. But the magistrate already just said, or he just said, that he's going to set an unaffordable bond. I know Vincent doesn't pull his punches. I know what he's about to say. It just doesn't matter at this point. I think he just needs to, take the win.
These are matters of interpretation. We have witnesses here. We have an individual who went to another individual's workplace while he had a PPO. In another situation, we had camera surveillance that observed this defendant doing what she did. So I just wanted to clear that up. And Judge, I apologize. I wouldn't usually do this because I know you were right in the middle of things.
No worries. Thank you for the additional information. For those reasons, bond will be set in the amount of a $20,000, 10% with the following conditions. During this bond, no use of alcohol, no illegal controlled substance. You're not to purchase or possess a firearm or any dangerous weapon. If you're able to make bond, Ms. Boykin, you will be fit with the GPS tether and I'll place you under house arrest. During this bond, you will do not go anywhere near the area or premises of 9644 Ostego in Detroit, and absolutely no contact with Tony Lamar Farmer, and have no contact of any kind, no contact orally in writing through a third party at their place of residency, employment, or through any forms of social media. It's my understanding you have a tether on another matter that you are to be fit, that you thought you were going to the Ostego address. Do not go back to that area or location until told otherwise by a judge. That's unaffordable bond according to counsel. So the court setting an unaffordable redetermination hearing, Ms. Boykin, 2 days from today, February 15th, 2024, 9 a.m. via Zoom in front of Chief Judge McConico. You'll attend that court date if you're unable to post bond. Ms. Boykin, do you have any questions regarding your court date or bond conditions?
No, what about, I already got a personal bond.
That was another matter that you got. That was another matter, not on this matter. I gave you the bond that I just stated, 20,000, 10%.
So am I still gonna get out on that matter?
Well, you have a personal bond on that matter. You still got to address this matter. Okay. Anything from the people or defense?
No, I appreciate you hearing me out, Judge. Thank you.
Thank you, defense.
That they're still all allegations.
All right. Yeah, that just happened. So that happened. You guys want to see some Simpson? I know we have some Bufflip action. Oh, I got a little clip of Bufflip dancing. I'm trying to figure out how I can use that. It's only about a 3-second clip. You know how most judges call defendants out for having their hands in their pockets? Well, the Bufflip was doing this little. It wasn't really a dance, but he was animated for a couple seconds, trying to tell the defendant to take his hands out of his pocket, but he didn't want to interrupt the judge. So he was just moving his arms. It almost looked like he was doing a chicken dance. So it was kind of funny. Anyways, let's go to Judge Simpson.
Good morning, Your Honor. Mark Watt on behalf of the defendant, Mr. Pierre Jefferson, is present in court. Standing to my immediate right. Pierre Jefferson. Your Honor, we have had an opportunity to.
Your name, sir?
Pierre Jefferson.
Thank you.
We have had the opportunity, Your Honor, to have the PCC, and we are set to go to exam at the next available date. If I may briefly address bond.
Discovery ready?
Yes, Your Honor, discovery is complete.
I believe so, Your Honor. There might be some videos outstanding. I will look into that today and get anything turned over as soon as possible.
People have their witnesses available March 5th. Preliminary examination will be set March 5th, 2024, 9 a.m. in person. That will be before Judge Perry.
Thank you.
Bond, briefly.
Yeah, as to bond, Your Honor, Mr. Jefferson is a lifetime resident of the state of Michigan. I do understand these are capital offenses he's charged with. However, the presumption of innocence must weigh in, and the bond that's currently set is tantamount to remand. Has insufficient funds to come anywhere near.
But it's to CSC first. He could be remanded without bond.
True statement, Your Honor. However,
I know.
However, we're asking the court to lower the bond.
Response from the people.
Your Honor, I'm going to request that bond remain as it is. The accusations in this case are incredibly serious, that the defendant was engaging in contact with the victim, who was a sex worker, and held a knife to her throat while he assaulted her. In addition, I understand he's on pretrial federal release for weapons offenses and fraud, and has bench warrants outstanding in the 15th District Court. So I believe bond is appropriate.
He was on federal release when
Your Honor,
these allegations came up?
Your Honor, he was on federal release and he's being.
When these allegations arose?
Yes, Your Honor, when these.
Motion for bond reduction denied.
Your Honor, if I may finish, please, briefly, if we may.
Go ahead, so I can just get to what I'm gonna.
Part of his release was.
Yeah. I don't know who this defense attorney is. I haven't seen him very often. I'm going to guess, I don't know, but I'm going to guess that he hasn't been in front of Simpson a lot. Judge Simpson rarely ever lowers a bond. It's a running joke, and he'll joke about it. He jokes about it all the time. He rarely ever does it. Yeah, he already made his ruling. How do you think it's going to end? How do you think it's going to end?
He clear up his warrants. He surrendered himself voluntarily on.
He was on
February
pretrial
14th.
release when these allegations came up. They are capital cases, counsel. I don't know what you want me to do. Quite frankly, I think the bond's set too low. Motion for bond reduction denied. Thank you.
Thank you for your consideration, Your Honor.
Don't get smart with me, counsel. That won't work well for you. Court calls the case of the people versus Mary Angelo.
Do not get smart with me, counsel. Do not get smart with me. He was the counsel. He got smart with them. Anyways, no, I am so glad you're here for this, and I hope you haven't seen this next clip. I kept this clip in just hoping you would be here. I've got one word to say. Shepke!
Good morning, Your Honor. Mr. Shemke, appearing on behalf of my client, approach will be standing to my immediate left. Oh, I'm sorry. To my immediate right, Judge.
You've done this before. All right. Your name, ma'am?
Mary Rose Angelo.
Thank you.
Judge, we're here for a PCC. I was just retained on this case. I have made contact with the prosecutor. I'm going to be asking for an adjournment. We're going to waive any time provisions. If possible, Judge, I find this matter potentially, it will not go to a preliminary exam. I'm going to ask for a 30-day adjournment, potentially if the court date would allow, the court would allow March 21st. Possible.
First.
Yes, Judge, and I will not be asking for any other adjournments.
Yes, you will.
I won't, Judge.
No,
I promise.
Yes, you will. Any objection from the people? Probable cause adjourned March 21st, 2024, 9 a.m.
Thank you, Your Honor.
Thank you.
You know, I've never really hated too much on Shemke. Sometimes I think he needs to stop his clients from talking. This is from watching DeSanto for a long time. You know, he's still an attorney. I feel like sometimes he fights harder for some clients than others. But all that aside, what he just did right there is he walked into Simpson's court and he owned the courtroom for that short amount of time. He walked up there, spoke very clearly. He nailed it. I was very proud of him in that. So, yeah, I'm very glad no one was here to see that because I feel like we have the same opinion on Shemke. All right, I think we have one more case here in Simpson before we move on.
The case of the people versus Tracy Benson. 2 cases. Other side.
Oh, I just, was you pointing over there?
No, I was asking him.
Oh, okay.
Ready, Judge? Oh, no, it's,
Prosecutors on Zoom.
Hi, and good morning, Your Honor. Chris Fleming, P75946, appearing on behalf of the people, special prosecuting from Lenawee County.
Thank you, sir.
Ready, Judge Torshio Feaster, Assistant Public Defender on behalf of Mr. Tracy Vincent to my right at the podium. Please state your name for the record. Mr. Vincent.
Tracy Alexander Vincent.
Same time set for a PCC in this matter, Judge. I believe this is also a forensic evaluation we're waiting for that has not come back yet. They are trying to restore Mr. Vincent to competency, and I do not have a copy of any update. I don't know if Mr. Fleming had, I do not have.
It looks like the last update we received was from February 5th, indicating the time on 23F55048 has expired, but the time on 23F55044 has not as of yet. So I will leave it into the honor's discretion what we do with the 5048 case. But it looks like we're still waiting for admission on the 5044.
So it seems to me that the best move would be to adjourn both out. unless
Sounds
there's
good.
an objection.
Sounds good to me, Judge.
Oh man, I missed that one. I skimmed a lot. I skimmed through a lot of Simpson today, and his docket was long. So generally, when it's only an hour or 2 hour docket, every time when I'm skimming, every time I click the little time bar to move forward, it generally jumps ahead about 15 to 20 seconds. When you're about 5 hours behind something and you're trying to skim through it, you're skipping like 5 to 7 minutes every time, which is a whole hearing. So yeah, I missed that one.
Mr. Vincent.
Remember we spoke about?
I'm doing.
Okay.
Mr. Vincent does want me to make a request, Your Honor. Obviously, this matter was preferred for competency. Mr. Vincent would like to have a hearing on his competency. Although I do not have any additional information to add, we have not done an independent evaluation, but he would like to have a hearing on that matter if the court would allow. I don't have any additional.
Well, we're waiting on one other report.
I understand that, Judge, but he wants me to request a hearing. I told him I would do that, Judge.
Your Honor, under the Michigan law 3302020, a defendant can only be determined incompetent to stand trial if they are incapable of understanding the nature and the object of the proceedings against them. My attorney can tell you that I'm not.
Can rationally assist in their defense,
Yeah,
which I don't know.
exactly.
Which I don't know that you're doing right now, but go ahead.
Sorry, I didn't. But my attorney can tell you that even my attorney, Andrew Banners, back in April last year, stated that I was not incompetent.
All right, this Andrew attorney that he's talking about, I don't know what he said. Andrew Bennett, maybe. He's in the screen right now. Sitting behind the defense attorney Vincent. I don't remember I always just call him Vincent, but he's the guy with the tie on next to the lady with the yellow shirt. Just watch him during this because this defendant brings him up multiple times.
To stand trial, police officers put in the report that I made statements that I was suicidal, that I wanted to get murdered, statements that I didn't make that can be found on the body cameras that I did not make. And it's false statements that was made that committed me to the treatment that I'm being sent to right now, which is illegal. It's also a felony under the Michigan law 750-410A. So I did not make any statements. I understand the nature of the proceedings against me. I understand the charges. I understand the preliminary exam. This is my first time in here. You know what I mean? And I just like to request a hearing to challenge the forensic.
On one of your cases, I don't have a report.
So he has to wait for your report, he's saying, for the second case that has not come back yet.
Right, but they've already said I was incompetent to stand trial, and I've been incompetent the whole time. That's what I'm saying. I've understood the nature of the proceedings the whole time. Even Andrew Banner said it back in April last year, and this is holding me up in violation of my Sixth Amendment rights.
Where are you going, Mr. Banner?
If you can remember.
Obviously, Judge, I'm not a doctor, and either is Mr. Bennett to my knowledge. But I have been able to communicate with Mr. Vincent, but I don't have any additional information to provide. I don't have an independent evaluation. I have nothing to offer in terms of evidence, but he would like to have a hearing on that issue otherwise.
Doesn't make any sense to do one and then the other report because I have no idea what that's going to say.
Understood.
So I'm going to adjourn a competency hearing. I don't have the report. And what I will do, and Mr. Vincent, listen very closely. I guess if you've read the statute, you understand how this works. I'm going to give you a date that's going to be in April. However, if a report comes in before then, it can be set earlier than that.
Okay.
It will be moved up. Understood?
Yes, sir.
I think he has one more request, Judge.
Okay, let me set the date and then I'll deal with the request. Go ahead. The hearings will be set for April 4th, 2024. 9 AM. What's his other request?
Your Honor, I think he wants to address this bond.
Go ahead.
He's
That's,
been-
that's worked very well today.
Yeah, I understand, Judge. He's been incarcerated, I believe, for over 7 months on this matter. 11 months on this matter, Judge. Obviously, he's still pending the forensic evaluation being completed, but he would like the court to consider addressing his bond. I do know his mother is involved in his life. She did come to his last court date to support him. We would ask the court to consider a reduction in his bond despite the pending forensic evaluation, Your Honor.
Response from the people.
Judge, these are very serious cases. He has quite an extensive record. People would request bond remain the same.
His bond is set actually at a relatively minimal amount of 5,000 cash surety each case, given the nature of the charges. Motion for bond reduction is denied.
Please, I'm just gonna leave it where it is. We'll talk.
Thank you.
Thank you very much, Judge. Appreciate
Bond
it.
will continue.
Yeah. Is he incompetent though? For someone to be up there to be able to cite, I don't know if he cited the right statute or whatever he cited. I don't know if it was correct or not, but he seemed with it to me. I don't know where the bar is for competency. I really don't. But I don't see why. I mean, does it just take saying one thing that's, kind of stupid, and all of a sudden your lawyer's like, we're gonna chalk this up to a competency exam? Like, I kind of want to know the answer to that question. All right, we are going into the last clip, and it's a short one. Might only be 2 minutes long. We're going to jump over to Judge Washington, and after this video, there were some laughs, but there were a lot of tough cases in this video. I know, so we're gonna end with some laughs. Again, 2-minute video, and so I'm just gonna let it play through. Let the outro go, and then we're gonna go hang out in Discord. So yeah, thanks everyone for coming. Hope you guys had a great night. Thank you everybody. Thank you to the lovely mods that always do a great job. And I will see you next time. Bye.
Mr. Jermaine Hamilton, case number 23T00025.
Paul Barnett on behalf of the township.
As well as 21S391000A.
Your Honor, I believe I have one of those too. Rachel McDuffie for the people. It was breaking up.
You do have one. I'm
sorry.
I'm beginning to think it's your device, Ms. McDuffie.
Probably.
All right. We're here for final settlement conference. I think just in the 23T00025.
That's correct, Your Honor. The township candidly is not in a position to proceed, but I don't see Mr. Hamilton here either, so.
Oh, but the FTA. Oh, that's the morning doc. All right, where's your client at?
I am trying to see, I did not speak with him. It looks like voicemails were left for him and he did not call back. So no one spoke with him.
And it failed to appear for final settlement conference today. What is your request?
Well, I'm asking for an adjournment or a show cause, but I have a feeling Ms. McDuffie and Mr. Barnett will not be asking.
Your Honor, I'm leaving your discretion. I guess I wouldn't object to a show cause given the fact that I don't have a victim here.
I have traffic tickets, so I really don't care.
All right, this is a failure to stop.
Well, I'll ask for a show cause.
Okay, it's been a long day already. I can tell. Just said.
Thanks, Sparkle Poots. I appreciate it. I'm glad you found it.
That out loud.
I'm sorry. I was supposed to censor that.
All right.
That's what the mute button is for.
When I do that, I don't come back on time. You gotta
All right, I'm gonna schedule these for show causes. Since you are unable to proceed, write my note here though. Show cause in this matter will be scheduled for March 21st. Huh? Oh wait, it's
It's a township. Oh, darn it.
So we need it.
Yeah, we need a Tuesday. 1 second. All right, March.
I'm gonna pause for it. Thanks, Legal Fiction. I appreciate it.
March 19th, 2000 and wait, 1 second.
Yes, I'm sorry. Yes, that is good.
All right, March 19th, 2024 at 9 a.m. for all of these matters. Both of them, however many it is. Okay. All right, we have 2 failure to appears from the morning docket that we still need to address.
Nice try, Johnny. I don't even have to pause to talk to you.
This is Amarion Jordan, case number 23 FB 1166.
Rachel McDuffie for the people.
Assistant Public Defender.